Welcome to this last panel of our annual ACELG conference. As you know already, the general theme of the conference is regulating Europe under uncertainty. In this last panel, we will tackle specifically the climate crisis and the specificity of regulatory interventions in a context of indeed global climate crisis. Maybe a couple of things before starting. I have been threatened by the organizer, Giacomo, about timekeeping. So panelists will have 12 minutes, and then so we can open the floor for the debate and the Q&A. I'm Alberto Nicotina. I'm a postdoc here at the Amsterdam Law School at the ACELG, working within Christina's ERC project on strategic climate litigation's direct and indirect consequences on democracy. And together with me, here there is Christina Eckes, indeed. She will talk about the knowledge and uncertainty in climate policy and in climate litigation today. Next to me, Team Bleeker from the Amsterdam. We'll talk about corporate transition planning and the uncertain scenarios it raises. And together, my colleague Yannick from Berg here from the University of Amsterdam, the private law department. We will talk about social practice theory, applying social practice theory to legal frameworks, and we'll explore how everyday habits might drive social change. So we'll first give the floor to Christina, who's also the only one to have the PowerPoint presentation.
I was also bullied into this by Giacomo to bring slides, so I made slides. Apparently not everyone at the same note.
Bullying.
Yeah. Giacomo asked me to speak not just about uncertainties, but also about certainty, to introduce a tiny bit of a contrast. So I'm going to speak a bit of both. And I want to start by saying that we in our project, well, I should say that if I'm asked to speak about uncertainty and regulation, I'm still speaking about uncertainty in climate litigation, because that's the only context I speak about at this point. So I should say that as a starter. And I want to show to you some uncertainty and how it plays out in these climate litigation cases. And we started with state cases. So we started with general mitigation cases against states, agenda type. And there we must start from the assumption that certain things are just certain. They're really not uncertain. And even if some private lawyers try to show us the causality link, I've been at several of these conferences, believe me, Tim, and they say it's a very long causal link. And then they start with, yes, there's emissions, and then there's temperatures, and we have to lay a link. No, that link is safely established. So I think it's a bit of window dressing to say it's a very long causal link. The problems come much later, and there are problems, but not at that stage. So what I want to show you here is the budget and the expected temperature increase, and it is linked to a certain likelihood that is here indicated as 50%. And this is at the second highest level of IPCC certainty. So this is highly certain. The confidence, with high confidence, the IPCC establishes this. So there's absolutely no doubt. The little blue part is what is left for 50% chance to stay below 1.5 degrees, and the orange is what we have used already. And this is at the beginning of 2025, so now this should again be adapted, obviously, below 100 gigatons. So I always think that's important to sink in. And these cases that we started with actually look at turning the tap, so closing the water pouring into this bathtub. And I make here the distinction, and maybe that's not conceptually entirely right, between the tap and the bucket. The bucket is individual policies. So when individual policies are established, such as trade agreements that trade in high emission goods, but also choices of, yesterday we spoke about type approval in the automotive industry. So do we approve, again, a new range of even heavier SUVs and allow even more energy inefficient cars to enter that fleet? That is the bucket here. And I understand the two are, of course, related, regulatory and implementation. But this is hence the cases where we have very little scientific uncertainty. Turning the tap, reducing emissions, overall targets of emission reduction. The uncertainty that we have does not come from science. So it's not the top down side, the right side. The uncertainty that we have comes from the right side. So the question of, I mean, here it says human rights, but also the question of what is fair, hence. So common but differentiated responsibility, the question of how do we divide this share of emissions that we have left if we think about the 1.5 as the political aim that we have set. So this is all very certain, and these cases, therefore, also don't fail on science. If they fail on anything, they fail on something else. It doesn't mean that there's not legal challenges, but no scientific challenges at the systematic level. What we have is a lot of uncertainty in respect to climate impacts. So I'm showing you here 3 examples to show you that we do know that we're going to reach the 1.5, how quickly the emissions, as I say, high level of certainty. But what we don't know is exactly what does that mean. And here I'm showing you, just for your entertainment, how the insights, scientific insights, have developed since 2001 on when we're going to hit tipping points, so-called tipping points, hence large-scale singular events that lead to shifts in climate. And as you can see, and that's the only thing I really want you to take in from this graph, and as all my graphs, these are either taken from the IPCC or from the Potsdam Institute on climate impact, climate change. So hence, they are all well-established climate science. I've not tried to change them in any way. I'm not a climate scientist. So what we see here is that in 2001, we believed that the tipping points came with high certainty at warming. I'm sorry, I'm not wearing my glasses. 6 degrees or something. That's when we're turning red. And you see now we're already at 6 degrees. We have already decided we will have tipping points. The whole situation, the whole planetary conditions will change in a way that we're not even discussing 6 degrees any longer as a sort of livable planet where we can have our societies as we have them now. So what we see now, we're already at red, somewhere between 2, let's say around 2 degrees. So tipping points we have understood in the past, and this is the final bar, as you see, is from 2022. So what we have understood between 2001 and 2022, that tipping points are going to reach us much, much earlier. And it's just one example. I'm going to give you 2 more examples. Glacier melting. So we thought that glacier melting would become a serious problem in the sense of that some people don't have water and other people have too much water as a result of the glacier melting. We thought that this was going to kick in approximately around 2050. Change that. So we see already a glacier melting that is more than 10% higher than we expected in 2025. And that is no modeling then, that's an observation. And there's a difference always between modeling the future, so what do we expect to happen, and by simply basically measuring what happens to the glaciers. So we already have these shortages and overflowing of waters and glacier lakes leading to floods, including in Europe. So everything I say is also related as of now in any event to Europe. Similar with heat waves. So we expected the UK to hit the 40-degree level in about a decade. We have already had this in 2022. So the map is from 2022 because that was a particularly warm year with a particularly high heat waves. Every year since has been warmer, but the heat waves have been more intense in 2022. So every year the temperature have gone further up. We have 50 to 60,000 premature deaths because of climate change in Europe per year because of heat waves. I just want you to compare that to COVID in your mind to realize what the impacts of climate change are that we did not expect to happen before 2035, but we have already encountered them before 2025. So these are all where science has predicted certain things, and we have actually ended up much worse when we now measure and count and look around us. How does it connect to climate litigation? Ultimately, that's probably what you want to hear from me. And I want to bring you back to legal truth finding. And I think I want to point out a number of things. So general emission reduction cases, as I said, are scientifically fully established. As the Canadian judge in Matua framed it, there's no individual expert that could make me rethink IPCC science as not as a bottom line. I mean, she also points out that it is mainstream and probably conservative, but she says in the way it is established with the high certainty, there's no individual expert that you could bring to this court that could make me reconsider this. But it plays in different things, and I see somehow these come on in a bit odd order. So in terms of causality, currently I'm writing a paper, and I already admitted to this to Tim, on private law cases against major emitters. And what we're looking at is collective standing versus individual standing. So if you want to connect this to cases, and you're familiar with the cases, there's Milieu Defensive Shell, where we have standing of a public interest organization as opposed to Volkswagen, BMW, BMW, well, I obviously put that in the wrong order, and Mercedes in Germany, where you have individual claimants. And you have this distinction between public interest organizations and individual claimants simply because of the construction of the jurisdiction. But it has far-reaching consequences, because in the first case, you can show basically statistical causality. You can show what the IPCC does, or what a scientific advisory body would do at national level. You can show that on average, the Dutch citizen suffers in a particular way. So when whatever, everything from sea level rise to heat waves to whatever you're thinking about, extreme weather events in terms of extreme rainfalls, what is the consequence in the Netherlands, potentially even for particular groups, whatever, farmers. And in individual standing, you have to show that the individual is affected. And there you have in private law, different also from public law. So this is the move from the general emission reduction cases where everything is certain to private law. You have the bilateral relationship. So you don't only have to show that there's a link between emissions and climate and rising temperatures and extreme weather events, but you have to link that you have to show that the two parties are actually linked. So you have to show the contribution of the individual defendant to these emissions. That is often a very small share, because even if you look only at the 90 carbon majors, you come out, and we saw that in UIA versus RWE, to percentages of 0.47. You come to very low percentages. So that is something that some people see as something that it could fail on. I'm going to say a moment later on whether it fails on that. But you also have to link that on the other side of the causal chain, you have to link it back to the plaintiff, so that the harm that the plaintiff encounters, whatever it is, whatever you imagine as the harm, it could be not being able to leave their house, if you look at Klimaseniorin, and again, a case against states, or if you look at Yuya in RWE, the fact that his house in Peru was threatened by the glacier lake, you have to show that actually that harm is immediate, so that it is, if it hasn't happened yet, so harm or hazard, if it's a hazard, that it's immediate, so that there is a reason under the law to protect him, also under private law, and that hazard, harm, the impending harm, the harm that is coming up, is actually linked to climate change, and that it has been either become much worse, much more likely because of climate change. And on that side, it is particularly difficult, because there you have other external factors. So in UIA, the harm is what it failed on. While the court accepted standing, while the court said there is an individual relationship between the two, the court accepted jurisdiction, and the court accepted also that the 47% of emissions that RWE contributes to global emissions is all sufficiently established, and hence opened the door for potential further legislation. What it let it fail on is that it said that the experts didn't show that the harm that the glacier lake would overflow basically and would threaten his house was sufficiently immediate. It was below 1% or around 1%. The experts stated, and that was not sufficient. Okay, many people have said, who are in the business of climate litigation, that it was due to the fact that they were the wrong experts and that you could have done this better. But it failed on fact finding. It didn't find on the law. It failed on something that you could either say uncertainty, because we didn't have the science to show this, but it didn't fail on any condition in the law that you couldn't meet in the future. Remedy and shell, slightly different. Here again, we failed on an uncertainty, if you like, or at least something that you scientifically would have to show, or that you have to accept that legal truth finding is very different from scientific truth finding, because there is that difference, and maybe that it becomes less obvious in the harm for UIA, because if it's at 1%, I suppose you would not expect the judge to say that it's sufficiently immediate. But the remedy and shell really shows how much it's about the framing of the law, of whether something is actually evidence in court. So it is not whether it is a fact, whether you establish causality, whether there is a scientific link, but whether it's accepted as evidence. And that is really part of how it's framed in the law, but it has to be shown to the satisfaction of the court. And the remedy and shell, that is, of course, what has been criticized harshly. So on appeal in 2024, in November, the Court of Appeal basically, did not grant Milieudefensie the remedy they wanted. And the main reason why they did not do it, and they had already passed questions of standing and of Shell's contribution, But the reason why they did not give them a remedy was essentially by saying it's ineffective. So whatever we expect Shell to do, either it is substituted elsewhere or the contribution is very small. So it came to the conclusion that there was no relief, that it couldn't show that there's a causal chain between Shell changing whatever Shell is doing and the harm of the defendants, the applicants. The applicants being, again, as I said, public interest organization, so all citizens of the Netherlands in that case. And I'm not, going to go into distinction between people elsewhere and people here. But it shows that the law frames it and how the law frames it. And I want to give maybe on a little side note that we see that everywhere. The question is, can we actually do that under law? That's one question I want to raise, because many people have criticized, or several people have criticized that. And this was also immediately what the lawyer of Shell, of course, raised, is then there is no remedy. So what you find, there's an obligation for Shell to reduce, or there's a duty of care for Shell to protect. The human rights were found applicable, and maybe the argument of the court was not perfect, but they did find a horizontal application of human rights via torts law. So they relied on human rights. And then the question, of course, under the European Convention on Human Rights is if you have a right and your right is infringed, you need a remedy. And if you're left without a remedy, that in itself is an infringement of Article 13, Article 6, potentially in any event. So here we actually left the Milieu Defensie with the situation that they proved that Shell had a duty of care, that Shell should have done something, but the court didn't come down on telling them to do something. And this is basically because they couldn't find the causal link. So there was an uncertainty about this link back of what Shell could do and how that could address the harm of the applicants. And similarly, that happens in all the cases that I showed you in Germany, the Volkswagen, BMW, and Mercedes cases, where in all of these cases, the defendant raised the point that by granting the remedy that the plaintiffs asked for, which was apart from the general emission reductions, that they should stop putting internal combustion engines on the market in 2030, so earlier than whatever regulation we might or might not get in Europe, would not be addressing the harm of the applicants. So that there was no link back between these car companies not putting internal combustion engines on the market and the harm of the applicant, because it would be substituted elsewhere. So other car companies would sell internal combustion engines, but also because the contribution would be small. So both arguments were made by the car companies. And the final thing that it failed on actually in Volkswagen, BMW, and Mercedes was not even that, but that was that, what at least in Volkswagen, what it failed on was that the case was based on an extension of Neubauer. So in Neubauer, the focus, again, a state case, was very much on if we don't reduce emissions now, we're going to have ad hoc emission reductions in the future. And then the court said you can't rely on that jurisprudence because Shell has no control over future emission reduction measures. So that shows you also how law strings what causality you need to prove. Obviously, you can't say, I mean, Shell is not the regulator. So, no, sorry, not Shell. Volkswagen is not the regulator. So Volkswagen will not determine how we need to reduce emissions in the future. But that shows how this jurisprudence develops and where new elements of competency can come up and needs to be shown and actually take us fully away from the question of inaction. And this is my final point, actually, because I see you getting nervous on that side. So I think a few points I want to make is the more granular it gets. So when you have individuals standing and when you need to show the causal relationship on both sides of that chain to the plaintiff and to the defendant in relation to that individual defendant, either do has a causal impact, emission reduction, that they can actually control future emission reductions, and that the harm is linked to that causal chain, that is often much more difficult to show for external factors. And legal truth finding is a normative choice. So it's a normative choice how to deal with uncertainty. And we have many cases where judges have significantly departed from what science evidence shows. And I give you just one example. It's the backlash when you have a car accident. It is safely established that you can claim damages, despite the fact that many medics have shown that this whole phenomenon of a backlash from crashing into something where you get the neck pain is actually very doubtful, and that you cannot link it back, that it's also an experience of the individual person, as one advantage. And this is where I stop, and I'm just going to tell you the fat printed part. The others are things that work against showing causality in the legal context, irrespective of what science shows you in causality. And the plus is where you can actually rely on law to argue that you don't need a high level of certainty, that it is sufficient to have a low level of certainty that this happens, because they all work in that direction in different ways, and I can explain that. But I think what I printed in fat is what comes through at least the 3 of the 4 things, and that is the greater the risk, the more precaution is needed. And that is accepted both in public law and in private law, in different legal contexts, here in the Kelderloik arrest, but also in Germany, we have clearly the establishment, the greater the risk, the more precaution is needed under tort law, as well as under constitutional law. And if you show, hence, the enormous risk from the enormous potential harm of climate change, and we are getting there to show that better, I said that at the beginning, that we are moving in the direction of seeing it's actually here and now and not in the future, then we should be able, with these principles, to adapt the legal truth finding in a way that any remaining uncertainties are not legally a problem.
I think we have many questions, but let's go on with team and let's have the question at the end.
Cool.
Please.
Thank you so much. Good to be here. Thank you for inviting me, even though knowing that private lawyers are prone to simplification. But I think the previous presentation set out the many certainties and uncertainties connected to forward-looking climate engagement. I think even though a lot is certain, still acknowledge there are still a lot of unknowns that you have to work with. For instance, you don't know how competitors exactly are going to react. You don't know whether the world's going to step up its game. There are perhaps uncertainties related to equilibrium climate sensitivity, how much radiative forcing is connected. So this gives us a 50% chance of limiting warming to 1.5 degrees. And it may get a lot worse. So far, as science advances, every time it seems to point in the directions that the risks are graver, so to say. And of course, so there's the climate sensitivity part. How will our climate system react to added emissions? It may be worse than we think, but then also what are the impacts and risks connected to this amount of warming? So even though a lot of certain and the science is settled to a great extent, we can agree, I think, that climate change as such already is complex and uncertain, which I agree should warrant extra caution. By the way, can I propose, if you go back to the presentation, could you perhaps press the B? Yeah, the W. Usually it turns white then. Perfect, thank you. All right, climate transition planning, and that's what I will be talking about, adds extra layers of complexity to climate change. And in this presentation, I'm going to cover 2 dimensions of uncertainty, but first I'm going to walk you through what corporate climate transition planning is, just to get up to speed. So as you may know, companies are required to align their conduct with climate objectives based on a myriad of regimes. And this doesn't happen spontaneously. They need planning to do this, right? So, and this is what climate transition planning refers to. They have to make a plan in which they set targets, reduction targets that are compatible with climate objectives. They have to translate these reduction targets into key actions, specific, identify various decarbonization levers that exist. They have to embed this plan in the organization, make sure the supervisory authorities are on board, that the monitoring is in place, and they have to make sure the plan is properly resourced. So this is basically what is connected to transition planning. So the first dimension of uncertainty perhaps regards to climate transition planning as such. For alignment, you should know that there is not yet a formal distribution key for countries. So the first hunch may be, let's stick to the global average, which is net zero in 2050 and 55% reduction in 2030, which, if we are overshooting, may already need to be steepened. But this is not a one-size-fits-all solution. Some companies or countries may need to do more even, and others can do less, because not all emissions are as necessary, or some emissions may be harder to abate than others. There's also distributional questions between now and future generations, between the global north and global south. So this already makes it perhaps hard to hold companies to account for a specific kind of trajectory, because they may kind of forum shop for routes that are horrible to them. So another example of an uncertainty on the current transition plan regards to the actions and levers. Because companies, as I said, have to translate these reduction targets into concrete actions. But there are many dependencies, for instance, whether they can get access to the energy grid, whether the labor market has sufficient capacity, whether, let's say, they get the right permits, whether they get everything financed. So here, just speaking of, and again, not nuancing the dangers of climate change as such, but the uncertainties and dependencies in climate transition planning, companies don't make this plan in a vacuum. They interlinked with various kinds of partners that they need to get there. So far, I've focused on mitigation, but also on the adaptation side, there are some challenges for companies. They have to not only make a plan how to align their conduct with the 1.5 degree world, according to the CSRD, they also need to assess what kind of vulnerabilities they have, what kind of outside-in risks exist for the company and how they operate. So, for instance, maybe their activities or assets are prone to droughts or weather extremes, or perhaps international instability may also give problems in the value chain. So we don't know yet what world we're going to, whether countries will step up their game or whether they get distracted by wars and other things, and whether we're going to a 3 or 4 degree world. Companies in their plan have to make scenarios for different kinds of directions this may go into. So they have to plan to become aligned with 1.5 degrees, but also prepare for when the world gets hotter, make sure that they can still maintain their operations or cover those risks. So I've promised to do 2 dimensions, and the first dimension is on climate transition planning as such. But now there's the other dimension of a fluctuating legal landscape. So you may have heard of the omnibus developments, where the Commission is supposedly simplify regulation for companies, which in effect means deregulation or even dismantling of what is out there. And well, the effects are perhaps visible if I mention a couple of examples. So one proposal by the Commission is to take out the phrase "to put into effect" transition plans. Right now, the formulation is they have to adopt a plan and put it into effect. And instead of this, it's proposed to make it to adopt a plan and describe implementing actions. So supposedly this is to alleviate the burden or to make it more simple, but I think it just creates a lot of confusion. Because you cannot report one thing and do something else completely different. The reporting has to be accurate and representative of what you do. Anything else may also trigger other kinds of regimes, like unfair commercial practices, or consumer protection, or liability law, greenwashing regimes, even fraud. So in other words, companies, if they report, if they make plans, if they promise things, they have to live up to it. Also, if you take away those words. So I think it just kind of muddles or kind of confuses the expectations companies may have, whereas they should be clear that this is not like just a window dressing exercise. Another example, the council, this is my personal favorite, is not the right word. What's the opposite? Oh, you'll hear. Anyways, they say that instead of making the plan compatible with climate objective, it should contribute to climate objectives. Now, what does that mean? I mean, recycling paper cups may be a contribution to climate change. This is completely useless as a legal criterion, and it will undermine the legal certainty, but also the level playing field for companies. In other words, compatibility, of course, as I mentioned, there are many questions of what that means. There's still a lot of debate surrounding this, but the advantage of compatibility is, even though it may not be possible to pinpoint what is sufficient to be compatible, it will be very much possible to say what isn't. So business as usual, or engaging in activities that are scientifically proven to be incompatible with the 1.5 scenario, like starting new oil fields, for instance, would be possible based on the compatibility requirements to kind of block. But if you turn it into contribution, it can mean anything, therefore nothing. So much for the simplification. And then finally, the provision in the CSDDD about corporate climate transition planning that I've been referring to before this is probably going to be watered down, as I said, delayed, but maybe even deleted. That's what the Parliament proposes in that position. So what would this mean? The reasoning is that the CSRD already covers a transition planning requirement, but make no mistake, the CSRD is no substitute for what is in the CSDDD. The CSRD, and the R stands for reporting, requires companies to disclose what they are doing to transition, disclosure plans, show color. And the CSDDD tells companies you have to transition, for which you need plans. So that's something very different. So this would not be streamlining, this would be a major step back. Now, one may reply to this that there are other regimes that also require companies to kind of align their conduct with climate objectives. And this is true. I mean, for instance, in the ETS, in product requirements, in consumer protection, in liability law, and human rights law, there are all kinds of obligations for companies that point in that direction. But the difference is right now it's a jigsaw puzzle. It's a patchwork of landscape. And it may vary depending on the sector that you're active in or the country where you operate. So if you want certainty, if you want to simplify, it would be a major step back to further dismantle the CSDDD in this regard. So that's the irony. I think I'm through my time. So to sum up, oh, wonderful. I can slowly sum up, but I think I can be very brief. What a mess. What a mess. I mean, if there's anything we need right now, it's kind of clear leadership and direction for companies, mindful of all the existential risks that are out there, mindful of the essential role they have to play. You cannot transition towards a sustainable economy without companies. So, yeah, I very much hope that the trilogue negotiations in Europe will provide some extra clarity. But things are not looking great, both in terms of where we're going with climate, but also in terms of what requirements exist for companies. And that's it. Thank you.
Timing, 12 minutes, 1 second. Yes,
thank you. I think it's a nice layout. So for me to follow this up by talking a bit less about perhaps litigation and the side of business, and more about what the EU legislator has done and can do. So in the time to my disposal, I would like to first emphasize how limited the EU approach to the climate crisis has been. And then second, after some negative words, say something about how it may use, especially social practice theories, to address at least some of the complexity of social transformations that are required for the green transition. And I'm going to be slightly provocative because it's a round table, I think. So just so you know, so we can have a nice discussion. So I would like to start out by agreeing with Christina that the uncertainty of the climate crisis is certainly not in whether the climate crisis is happening or whether it will be bad. If I think of uncertainty and the climate crisis, I am uncertain whether we will actually be able to do something about it. In many ways, the EU approach to climate change is a great example of why we might want to be skeptic about our collective ability to address this problem. In my doctoral thesis, I wrote about the EU approach to reducing EU aviation emissions, and even though the EU already acknowledged the particular climate risks of aviation in 1992, so over 30 years ago, emissions have since more than doubled. This is not surprising when we consider that the Union has done nothing to discourage flying in those 30 years. Policy efforts much rather focused on growing the aviation sector, making it more competitive, a word that has now returned with a vengeance, and hoping to innovate its way out of the crisis. And it is this narrative of growth and competitiveness paired with neoclassical methodological individualism, something that I will get back to later, that has been at the root of the Union's failure to address the climate crisis so far. That this narrative is the dominant one comes as no surprise to anyone that has looked at the Draghi report. Page 1 opens, and I quote, "Europe has been worrying about slowing growth since the start of this century. Various strategies to raise growth rates have come and gone, but the trend has remained unchanged." Nearing the end of this same page, our slowing growth rate is an existential threat. Because, he argues, Europe's fundamental values of prosperity, equity, freedom, peace, and democracy in a sustainable environment can only be provided for to its people by growing and becoming more productive. Economic growth then surely shall be our salvation, all the more ironic then that the climate policy is the first to be sacrificed at its altar. What the omnibus packages show us is that the neoliberal constitution of the European Union still stands firm. Economic growth trumps, pun intended, a livable planet. And this U-turn by the Commission is very problematic. But even in the Commission's more greener years, EU climate policy has always focused on innovation first and consumer choice second. The Green Deal was also a growth strategy, after all, aimed at decoupling emissions from economic growth. What is left out of all of these narratives is the question of demand. Why have we grown to have such energy-intensive appetites? And does a sustainable future really require us to produce even more energy? More importantly, is prosperity, equity, freedom, peace, and democracy really this energy-intensive, or is there an alternative future possible? These questions are barely ever asked, because the dominant economic models, and in particular our understanding of consumption, is still stuck in methodologically individualist understandings of said consumption. In rational choice theories and behavioral economics, the individual is most important, and their choices and behaviors are the explanation of how we consume and do things. Sustainable consumption then needs to be incentivized and nudged. Another way, however, to understand consumption, and one that I subscribe to, social practice theory. In particular, the practice theory coming from Elizabeth Shove, we've just been told to refer especially to our female colleagues, so I'm happy to do so. Practice theories see the shared social practices to be most important. Our day-to-day activities, from driving to showering and working, taking these practices to be central to our understanding of consumption and changing it gives a more complex understanding of consumption, the ways, the things we do, and especially policymakers can learn from them. So what happens when our policy looks at practices instead of individuals? Well, first, we see that our energy demand is the result of the shared social practice that we engage in. If we are to reduce our emissions, this depends not on individual decisions, but much rather the shared activities that we take up in our day-to-day lives and the material infrastructures that are required to make this happen. Charging my phone does not require that much energy, but the entire system of making phones work, and in particular data centers, does require quite a lot of energy. And these systems and materials that are required for the particular ways in which we go about our day-to-day practices is what energy is used for and thus what causes our emissions. As such, practice theories lay bare that demand is not simply there to be met, but that it is made and that it changes over time. 50 years ago, barely anyone was flying, and yet today we have 500,000 flights from Schiphol alone. So what happened? The increase in flying was not simply the result of increased supply and demand. If we look at the history, we see that the EU institutions favored demand growth as something to seek instead of being a problem. From the liberalization of aviation to the support of the European Travel Commission and traveling abroad, and to the many rules on safeguarding travelers and vacationers, especially, for instance, in the Package Travel Directive, the legal and policy regimes have served to make air travel more accessible, comfortable, and desirable. The past 50 years saw no efforts to reduce demand for air travel as a way of reducing emissions. In fact, it did the exact opposite. The second and arguably more important insight that we get from focusing on practices is that policies can modify and affect demand. Practice theories show that climate policy should focus on how our day-to-day lives can change to be less resource intensive. This does not mean that we should simply outlaw or make prohibitively expensive certain practices. Much rather, this requires us to see how we can set the conditions for more sustainable practices to take hold. If we take the example of flying again, we should be able to envision futures that revolve around less or no flying, at least for holiday. Reducing emissions from flying then is as much as about realizing accessible and affordable holidaying locations close by as it is about making flying less attractive. Instead of looking at the individual, hoping to change behaviors one by one, we need to change our larger ways of going about life, vacationing, but also traveling. But grounding ourselves in the complex relationships between the practices we engage in our daily lives, we should also see that there is an inherent uncertainty there. The policies may not always work out as expected, and our social reality is constantly in flux. But perhaps this is exactly where some hope lies in facing the climate crisis. We do not know how our future lives look like, or what practices stick or can be done without. In that sense, we do not know what prosperity, equity, freedom, peace, and democracy will look like in the future. What is clear, however, is that our current trajectory, in which we stick to the current and growing energy demands, will not have this take place in what we call a sustainable environment. What we require is a vision of the future that questions our current resource use. A future that does not take our current needs for granted, but recognizes the negotiability of need. What would a future without holiday flying, for instance, look like? And what does that require from us? What is a future with much less meat consumption, for example? And perhaps very salient today, what is a future where AI is not in everything? And we do not have 28% of our energy consumption going to data centers. These are futures that we can envision, and those are the questions that EU law will need to answer.